I am thrilled to have the legendary Dick Bluementhal here, my colleague in the Senate, the senator who has argued more cases in the Supreme Court than any other. And like me, he was Attorney General of his state and U.S. Attorney in his state, but for longer. So super distinguished prosecutorial career. And we are here to talk about Todd Blanch, who has a less distinguished prosecutorial career and yet is up for Attorney General of the United States. Dick, welcome.
Thank you so much for having me. Senator Whitehouse, legendary
yes, I'm legend.
Leader in Rhode Island.
Yeah, we're neighbors in addition to everything else. So one of the huge millstones that Todd Blanch is going to carry into his confirmation proceedings is going to be his role in the incompetence and obstruction around the Epstein files, for which he was completely thrown under the bus by Pam Bondi on her way out. Talk a little bit about what the problems were there and how he is responsible for that misconduct.
I think you've used the right words, obstruction, obfuscation, but I would add another, which is corruption. His concealment of those files was in large part to hide the involvement of Donald Trump, whose name was mentioned again and again. He failed to reveal that part of the file. He was in charge of protecting Donald Trump's interest at a time when he was second in charge of the United States Department of Justice. And I can't help but add that the Department of Justice should inspire reverence and respect. And in fact, it has for thousands of people who have worked there. And he has degraded it in his performance on the Epstein file by really destroying the credibility of the Department of Justice for truth-telling and honest dealings with the public as well as eventually with the courts.
How about his trip to Tallahassee to interview Ghislaine Maxwell?
Not only to interview her, but then to transfer her to a less stringent or strenuous facility, much more comfortable for her.
Club fed.
And it has to be because she probably agreed to stay quiet. That would be the circumstantial conclusion. But the appearance of his going to interview her, a main witness potentially against the president, simply reaffirms what he informed United States attorneys across the country February of this year, that the president is, quote, our chief client. And you and I know that's not what the Department of Justice should be doing. So the interview with Maxwell was simply, again, part and parcel of his acting as the president's lawyer, not the people's.
Yeah. And particularly when he covered up the 302s, the FBI agent reports of the young woman who testified to the FBI that she'd been physically assaulted and sexually assaulted at about age 15 by Donald Trump, mentioned him by name, and they still haven't produced the agent's notes. Talk a little bit about what a 302 is and agent notes so that people can understand how grotesque it was to cover those up.
When an FBI agent goes to interview a witness, in any case, everywhere, routinely, they have to, number one, take notes if they're physically able to do it, but number two, in any circumstance, produce a report that is known as a 302. And routinely, you and I use them in prosecutions to refresh witnesses because they have the authoritative transcription of quotes. They are the best possible, supposed to be objective view of the interview. And
you disclosed them to defense counsel in order for the defense counsel to be able to have the Brady obligations of the government met, to disclose and not, sneak up on and do surreptitious things against a defendant. And with Ghislaine Maxwell having been a defendant, while Blanch was covering up the 302, somebody realized, oh my God, Maxwell must have them. Her lawyers would have had them. They would have had to have been turned over. So the cover-up was going to blow at some point, and then only after they got caught did they release the 302s, but still not the notes. How about the suspicious activity reports that the Treasury turned over to the Department of Justice for Epstein accounts?
Again, as you and I have known from our experience, the routine is to follow the money. In this case, the money was really inculpatory. It involved potentially Epstein and others around him, including very possibly the President of the United States. And the irony here is that Blanch not only knew all this, he had dealt within the system. He's a former assistant United States attorney. He was a criminal lawyer as a prosecutor before he was a defense counsel. So it's not as if he couldn't have known or didn't know about the implications of what he was doing. He just decided to defy ethics, defy law, defy the norms and the rule of law.
And they're literally called suspicious activity reports. So a reasonably intelligent human could deduce that pursuing them might reveal some suspicious activity.
He seems to be more than reasonably intelligent.
Just a little bit corrupt on the side.
Yeah.
So he's got the Epstein millstone around his neck. On top of that, he has the what I call cop beaters slush fund, which actually may have been a payroll account for an attack on the upcoming elections in November, so that Trump's election disruption troops would have lots of money that have been sloshed out to them from this fund to fund their efforts to disrupt the coming election. And that's been a stinker for Republicans to have to deal with. And then parallel to that was the nasty Trump family and business tax amnesty. How did Blanch figure in all of that?
Well, he was the enabler. He made it happen. He was the one who agreed to the supposed settlement of the dispute, when in fact there was no dispute because
it
the
was
president—
Trump versus Trump in the case.
Exactly. But he engaged in this really mendacious pretense that courts are now looking into. But, as absolutely astonishingly outrageous as the slush fund, $1.8 billion to go to Trump's allies and friends, and to go to the cop beaters and the attackers on the Capitol, and to go to child molesters, convicted felons who attacked the Capitol and who were pardoned, subsequently committed felonies against children, child molestation. And they all were going to get money, supposedly because justice was weaponized against them. But the tax stuff was just so incredibly unprecedented and illegal to protect the president against any possible investigation for his past failure to pay taxes, which to him was worth probably about $100 million at least, as well as his family, was just beyond the bounds of any imagination. It would have been, laughable, but it was so serious. And I think we need to pause here for a second to recognize that these violations of trust are not victimless. In the case of the Epstein files, the survivors, those girls who were molested, were victims when there was a failure to disclose, but also when he disclosed actually their names in one of the releases of information.
That's the incompetent side as opposed to the corruption side.
One hopes it was incompetence and not just vindictiveness. And on the money that he was going to put in the slush fund, that's our money. That's taxpayer money, $1.8 billion. The $100 million that he was going to spare Trump from paying by the immunity that he gave him, that $100 million was money due to taxpayers. This is not some kind of bookkeeping, accounting error. It really has impacts on the total amount available.
So as a lawyer, the tax amnesty document looks pretty weird. It's an attachment to the settlement that creates the fund, the purported settlement, but it's not part of the settlement. It has no consideration. No other party signs it. Even Trump's lawyers didn't sign it. The actual client here is the Treasury and the Internal Revenue Service. Nobody from Treasury or the IRS was willing to sign it. Treasury's general counsel left.
He resigned.
And that may have had something to do with this particular mess. What you had was basically a blank piece of paper that says Trump's get out of jail free for any and all tax crimes, signed by Trump's former lawyer, Todd Blanch. Just as a legal document, doesn't it open enormous questions?
More than questions. It is really just so incredibly outrageous. I couldn't have imagined anyone doing it before he did it.
Well, let's dive down into Florida for a moment, because the settlement that created the slush fund resulted from a case that Trump had filed seeking $10 billion in damages from himself as president because he supposedly had tax disclosures that hurt him. And the judge was concerned down there that, is this a real case? It's like Trump on one side and Trump on the other. What's going on? So she asked in respected judges and counsel to advise her as friends of the court, and they wrote a little report saying, yeah, you've got a real question here, and you need to start asking these questions of the parties involved. And at that point, Trump's lawyers withdrew the complaint. So the case disappears. The judge signs the regular dismissal because nothing looks the least bit controversial. And then the settlement pops up in the caption of the dismissed case. And it either was entered into before the case was dismissed and not disclosed to the court, which is a problem, or they basically just hijacked the caption of the case and wrote a settlement underneath the caption of a case once the case was no longer existent, and then attached the tax amnesty document to that. That provoked 36 retired judges to blow the whistle and say, whoa, this smells like fraud on the court. And the trial judge agreed that there was enough here to open an inquiry. So let me ask you first about fraud on the court and the notion that senior officials in the Department of Justice were credibly enough accused of fraud on the court for an inquiry to be opened.
Unheard of. Never before.
Never before.
That's one response. How could it have happened? Well, it happened because Trump is the Attorney General's quote-unquote chief client, and he was willing to do for a client anything he could get away with. But fraud on the court has a very specific meaning, as we know as lawyers. It is about as bad as it gets. To commit fraud on the court is to completely destroy credibility. And it's not only fraud, which is obviously illegal, potentially criminal, but for a lawyer, it's about as bad as it gets. And here, any other client would have said, you know, that's a bridge too far. I don't want my lawyer to commit fraud on the court because ultimately that's going to redound against me. But Donald Trump is up to his neck in corruption in every other way, so many other ways, that I'm not sure he would have objected if he knew. But the implications could be really serious because it's fraud on this court.
Yep.
But the Department of Justice goes into every court in every state all around the country. Every federal court is a forum where that fraud on the court will have implications for the credibility of workaday assistant United States attorneys representing the United States of America.
In that context, tell us what the presumption of regularity is and how this damages it.
The presumption of regularity is what every government lawyer should have, which is that they are going into the court with the understanding and assumption
By the judge.
By the judge and everyone else.
Yeah, all the
by
parties.
Opposing counsel.
Yeah.
They're going to tell the truth. One of my favorite lines as United States Attorney in Connecticut was always from Justice Jackson when he was Attorney General of the United States.
Yeah.
And it was to the effect of the goal of a government lawyer is not to win the case, but to do justice. And that was one of the reasons why I revered the Department of Justice, because we went to court.
Strike hard blows, but not foul ones.
Exactly. And at the end of the day, what we try to do, and sometimes, by the way, it requires dismissing a case.
Yeah.
With a little bit of egg on our faces, because you don't necessarily know everything at the beginning of the case, but you have to be willing to admit error, to acknowledge and confess error, because the goal is to do justice. That's the presumption of regularity, that the government lawyer, United States attorney, everybody who works for him, is trying to get at the truth and get a just result. And that's why grand juries will credit the government lawyer who says, here's my understanding of the facts. It's why a jury in a trial will believe that government lawyer over defense counsel if their views are conflicting, and why the judge, if a lawyer cites a case to him, will assume the government lawyer is being truthful. And it is one of the ways that the system works, because the judge can't question everything the government lawyer says and go do the original research and ask for witnesses to show everything the government lawyer is claiming when a proffer of evidence is made, which is a way of saying
here's what we could prove.
Here's what our witness would say.
Yep.
Presumption of regularity says, okay, that's admissible or not, and takes it as a given.
So the presumption of regularity, for the first time ever that I can recall, is lost. Fraud on the court, for the first time, is credibly alleged against the Department of Justice. Let's go back to that Florida court where the judge opened the inquiry and asked for responses from the lawyers, specifically only named the plaintiffs, which would have been the Trump's private lawyers. But in her discussion of it, she questioned about whether DOJ policies had been violated, which is a question that DOJ would be in the best position to answer. Questioned whether DOJ's client, the IRS, had produced a defense memo that they had ignored, which would be a document in the possession of the DOJ, and questioned whether there was, in fact, deceit and collusion. And collusion requires two parties. So all of that points at the judge expecting an answer from the Department of Justice, setting aside this is the first time anybody's ever accused the Department of Justice of fraud and deceit. By God, we're going to rise up and defend ourselves against that. So for all of these reasons, we were waiting eagerly for what the Department of Justice was going to file pursuant to the judge's invitation, and they didn't file anything. They let the Trump lawyers file a terse little document. What does it tell you in those circumstances when the Department of Justice hides behind Trump's personal lawyers and won't answer a challenge like that from 36 retired judges and an invitation like that from a sitting federal judge that has challenged the very integrity of the leadership of the Department of Justice?
It shows me they know they're in deep you-know-what. Or to use a different analogy, they're in quicksand. And the best way to bury yourself in quicksand is to try moving. And I think they're trying to avoid doing anything in the hopes that they will be rescued. But I want to come back because someone who may not be familiar with all this and who may not have the background in law that we do, these are not victimless offenses, so to speak. presumption of regularity enables government lawyers to be effective. And if crimes are not properly prosecuted, there are victims who are not properly protected or their rights vindicated, just as the Epstein survivors are victims. And in the case of the capital attackers who were pardoned, 1,500 of them, and then in line to get this slush fund. You know, those Capitol Police, you and I know them. They put their lives on the line. Many were injured. And it is more than an insult. It is really to say to them, your lives are not really worth anything compared to these attackers, you know, the Proud Boys and all the
Oath Keepers and the rest of them.
Exactly.
You and I were both U.S. attorneys. I think that we also have reverence for that particular office within the Department of Justice. This Department of Justice has been repeatedly illegally appointing U.S. attorneys and trying to find their way around the constitutional requirement of advice and consent. And then they have also seen in multiple cases already, this far into Trump's second term, disciplinary concerns raised by courts about misconduct by the U.S. attorneys, sometimes illegally appointed U.S. attorneys. Pretty grave misconduct. In one case is the whole judicial panel of a federal district condemning the U.S. attorney for misconduct in front of a grand jury. How out of line is the effort to get questionable U.S. attorneys around the nominations process, and how unusual is it to see this record of catastrophe in court by U.S. attorneys?
Completely unprecedented. I've never seen a U.S. attorney in the position of being challenged by a judicial panel. And again, there are practical implications because a U.S. attorney signs the indictments. If the U.S. attorney is illegitimate, that indictment also is illegitimate. And there are a lot of defendants who are now going to be claiming that they were not properly indicted. And if they were tried or if they pleaded guilty, there's going to be a need to re-indict, perhaps retry or not those defendants. And they may have legitimate due process claims, all kinds of malicious prosecution claims. So it goes on, but even the United States Attorney for the Southern District of New York, Jay Clayton, who now has been nominated to be DNI, Director of National Intelligence, was involved in the Epstein review of documents. So the tentacles of this corruption reach across the country, and as you've rightly pointed out, a lot of U.S. attorneys are in very challengeable positions.
And apart from the corruption and misconduct aspect of it, just the plain incompetence of not being an effective prosecutor and getting the job done. How often, when you were U.S. attorney, did you get a grand jury to reject a proposed indictment?
That's a great question. The mantra is that a grand jury will indict a ham sandwich if the assistant U.S. attorney asks him to do it.
Which isn't quite true.
No.
What it reflects, though, is that U.S. attorneys don't go into court to seek an indictment unless they have the indictment buttoned down so clearly that little doubt remains. And it's a real red flag about the U.S. Attorney's Office's preparation when an indictment is rejected. I was U.S. Attorney 4 years. I don't think we ever failed to get an indictment. And it's not because grand jurors roll over easily for a prosecutor. It's because prosecutors don't go to grand juries until they've really professionally nailed down the case rock solid. So it's in that context that we see these no true bills.
We never had a no true bill. And I think your point is really important. To go to a grand jury, for me, always meant we had proof beyond a reasonable doubt.
Yep.
Why? Because eventually you're going to have to go to court and prove a case beyond reasonable doubt, or convince a defendant that you have proof beyond a reasonable doubt. That's the standard that ultimately you have to meet. And indicting someone is a supremely important act. In fact, I used to tell my staff the most important thing we do here is charge people. Because once someone is charged or indicted, half the world believes that person is guilty. It is a mark on that person, even if they're acquitted at trial. And no prosecutor I know wins 100% of the time, but I would hope no prosecutor would bring charges or an indictment without believing that there is proof beyond a reasonable doubt.
One other related rule is that once you've gone into the grand jury and once you have obtained an indictment, you then shut up about the defendant, except through pleadings that you file in court and statements that you make in court, because you can be accountable to the court for those statements if they're false or misleading, whether they're written or oral to the court. But you don't go out to the court of public opinion and smear the defendant. And that seems to be a principle that is lost on this Department of Justice as well.
Well, their MO is to smear people. You know, look at the indictments of Comey, Tish James, our colleagues who have been
Which indictment of Comey, the first fake one or the seashell fake one?
Both.
It's really remarkable.
I mean, we can laugh about it, but again, these kinds of wrongdoing and lawlessness are not victimless. Comey's going to have to spend a ton of money and spend a lot of energy and anxiety and worry on the part of his family. And they went after not only him, but his daughter, getting her fired. So the idea of smearing people is this administration's MO. And improper disclosure or comment, you need to look no further than Kash Patel, who has been actually wrong when he's tried to improperly disclose a potential defendant on a number of occasions.
Yeah, including with the Brown University shooting recently in Rhode Island that we had to live through, in which he shot his mouth off without knowing what he was talking about and identified someone when they simply had, at the end of the day, nothing to do with the shooting. But ultimately, I would say when you become a U.S. attorney, you take on a sense of duty and an array of principles that you understand need to guide your decisions. And that includes not taking unfair advantage, landing hard blows but not foul ones, seeking justice but not victory, back to Attorney General Jackson's prescriptions. And those things matter. They matter to people appreciating our system of justice. They matter to the individual on the receiving end of the indictment who deserves to be treated fairly and honorably all the way through until they're convicted and sent to prison and then treated fairly and honorably in prison as well. This whole notion of the Department of Justice as a weapon to destroy enemies is just antithetical to everything that we learned and believed in as attorneys general and as U.S. attorneys.
To use the Department of Justice as a weapon for political purposes is really unspeakably wrong as a matter of our constitutional and ethical standards. And those standards are what distinguish us from other countries all around the world. In the Soviet Union, Stalin had a head of secret police who said, "Show me the person and I'll show you the crime."
Yeah. And that's what they've done to
exactly.
enemy
What distinguishes
after enemy
us is
after enemy.
We demand standards, proof, ethics, and no one should embody it more than the Attorney General of the United States, and unfortunately, nobody has betrayed those standards more than Todd Blanch.
Perfect to end on. Thank you, Senator Blumenthal. Wonderful to have you on Making the Case
Thank you,
podcast.
Senator Whitehouse.